Mr. President, distinguished members of the Court, it is an honor and privilege to appear before this Court on behalf of the Republic of the Philippines. Together with the head of our delegation, Solicitor General Menardo Guevara, Ambassador Carlos Soreta, and Assistant Solicitor General Bernard Hernandez, the Philippines will address an issue which pertains to the greatest existential threat that we as a humanity face, the climate change crisis. The Philippines, as we speak, is at the tail end of the tropical cyclone season. But the recent 7 destructive typhoons that successively barreled through the country within a month's time were unprecedented in its frequency. In a matter of hours, homes were inundated, livelihoods shattered, years of development work swept away, and precious lives lost. Filipinos are resilient and have coped with calamities, but the typhoon's increasing severity is outstripping adaptive capacities. The reality of extreme weather events, rising sea levels, and other adverse effects of warming temperatures around the world, all of which are beyond natural climate variability, requires all of us to take bold and decisive actions. Mr. President, the Philippines has consistently understood the nexus between the environment, the well-being of states and peoples, and international peace and stability. For one, the Philippines now hosts the Loss and Damage Fund Board, a mechanism operationalized at COP28 as a lifeline for vulnerable peoples and places. In addition, President Ferdinand R. Marcos Jr., in his statement at the high-level general debate of the 77th session of the UN General Assembly, characterized the threats to kalikasan, the Filipino word for the natural environment, as the greatest threat affecting our nations and peoples. It is this understanding that informs our submissions to the Court as we address the request of the General Assembly. In fact, in September 2023, the Philippines urged the International Tribunal for the Law of the Sea to view the warming of our planet and the resulting changes to the natural environment as a threat to humanity and a key risk to international peace and stability. As we convey our gratitude to the Court for convening these oral proceedings, we look to it to provide authoritative guidance to address the worsening global catastrophe and to fulfill our respective obligations in ensuring the well-being of present and future generations in this shared home we call Earth. Mr. President, may I introduce Solicitor General Menardo Guevara, who will speak on the scientific consensus and Philippine situation, to be followed by Permanent Representative to the UN in Geneva, Carlos Soreta, to speak on the UN Charter, Human Rights, and UNCLOS. The Solicitor General will speak again to make further legal arguments and conclude with the Philippine government's submission. I thank you.
I thank His Excellency Eduardo Malaya. I now give the floor to Mr. Menardo Guevara. You have it.
Mr. President, Your Honors, the denial of climate change and the impact of anthropogenic emissions is negated by overwhelming scientific consensus. The 2023 synthesis report of the Intergovernmental Panel on Climate Change shows unprecedented global warming of 1.1 degrees Celsius above pre-industrial levels from 2011 to 2020, and has predicted that the warming will more likely reach or surpass 1.5 degrees Celsius between 2021 and 2040. This prediction has come to pass. As of August 2024, the Earth's temperature crossed a critical barrier never experienced in all of human history. The dire consequences of the increasing global temperature, such as severe and extreme weather events, intense heat waves, devastating typhoons with violent storm surges, prolonged droughts, wildfires, catastrophic floods, and their tremendous human toll are life and death realities for many developing states like the Philippines. They are not abstractions. The Philippines, a mid-ocean archipelago, perennially suffers the brunt of devastating tropical cyclones. Historically, East Asia experiences 20 tropical cyclones annually, and about 8 or 9 of them batter the Philippines with increasing frequency and intensity due to the climate change crisis. In December 2012, Super Typhoon Bofa, locally known as Pablo, made landfall in Davao Oriental Province and crossed over to Davao de Oro. These two provinces in southern Philippines have never before experienced super typhoons. Torrential rains generated enormous debris flow from the Mayo River watershed and wiped out an entire village, and in the process, displaced thousands of families, damaged billions of pesos worth of infrastructure and livelihood, and caused the loss of lives of hundreds of Filipinos. Coming on the heels of such devastation was Super Typhoon Haiyan, locally known as Yolanda, which made landfall as a Category 5 storm in the Philippines in November 2013. Its deadly and extremely destructive winds exceeded 315 kilometers per hour, causing storm surges that reached up to 5 meters high. It affected more than 14 million people across 44 provinces, claiming over 8,000 lives and displacing 4 million Filipinos. While undoubtedly the most powerful tropical cyclone to ever make landfall in recent memory, Super Typhoon Haiyan is less likely to hold this record for long. Over the course of 6 weeks, from 1 October to 14 November 2024, the Philippines experienced 7 typhoons. Of this number, 3 reached Super Typhoon category, namely Krathon, Kongray, and Manyi. And 1 reached Tropical Cyclone Warning Signal number 4, namely Yin Xing. 2 of those typhoons alone affected an estimated 9.6 million people, damaged 208,000 homes, displaced 258,000 people, and resulted in 158 deaths. While the typhoon and monsoon seasons bring torrential amounts of rain, the dry months, on the other hand, cause unprecedented levels of extreme heat indices. When we are not being drenched, we are being scorched. In May 2024, the highest recorded heat index in the Philippines reached an alarming 55 degrees Celsius, an extreme danger category which caused successive class suspensions, significantly affecting the quality of education of hundreds of thousands of school children. Data from the Philippine Education Department show that in recent past, an annual average of almost 15 days of on-site learning were lost on account of extreme heat. Not only that, The extreme danger heat index contributed to serious loss in agricultural productivity, affected power supply, and exposed vulnerable sectors of society, such as the elderly, children, pregnant women, and persons with respiratory illnesses, to heat stroke, and in some cases, death. Moreover, in our oceans, higher atmospheric temperature has caused major concerns about rising sea temperatures, ocean acidification, and coral bleaching. These phenomena ultimately affect the ocean biodiversity that is essential to food security and the livelihood of millions of Filipino fisherfolk. Filipino marine biologists have found extensive coral damage in Escoda Shoal, which they attribute to the anomalous warming of the waters in the West Philippine Sea.
My name is Jonathan Anticamara. So my main research is on coral reefs. We go around the Philippines to survey different coral reefs around the country, from the northern part, Apari, all the way to Tawi-Tawi. The most recent surveys and research that I did were in the West Philippine Sea. In April, we went to Pag-asa Island, and then in June, we went to Escoda Shoal to look at what's the status of corals. Both in Pag-asa and in Escoda Shoal, most of the corals, in fact, majority of the corals are either dead or dying, like bleach, and they are now covered in algae. So it's in various stages of degradation. So my conclusion that they're extensively dead, this was mainly due to climate change, such as warming, was drawn mainly from our observation first in Escoda, wherein almost 100% of all the corals are bleached. This kind of bleaching cannot be attributed to localized pressure or disturbances such as pollution. We thought that this phenomenon or this trend is actually attributable to the warming that we experience in the summer. So this must be a climate impact.
It is our humble submission, Mr. President, that this environmental crisis attributed to anthropogenic GHG emissions is surely not experienced in isolation by the Philippines. As we have learned from Vanuatu, the Bahamas, Bangladesh, and South Africa, among others, these unusual and unprecedented climate changes have become a global phenomenon. Mr. President, at this point, I turn over the floor to Ambassador Soreta.
I thank Mr. Guevara. I now give the floor to His Excellency Carlos Soreta. You have the floor.
Mr. President, Your Honors, I will speak on the UN Charter, human rights, and UNCLOS. Mr. President, climate change is a critical environmental issue, but it is also a serious threat to the maintenance of peace and security of mankind, the maintenance of which is a solemn obligation under the UN Charter. Rising sea levels, extreme weather events, and resource scarcity fueled by the climate crisis destabilize regions, exacerbate conflicts, displace peoples, and imperil sovereignty and territorial integrity. The complex crisis creates unprecedented challenges, particularly for marginalized and resource-limited populations. The request pays special attention to small island developing states, and the Philippines finds affinity with their plight as a nation with thousands of small populated islands facing very complicated maritime disputes. The Charter's provisions on sovereignty and territorial integrity resonate in this context. Climate change-induced sea level rise poses a severe threat to the territorial integrity of low-lying and island nations, analogous to the loss of territory by invasion through the use of force, but without the possibility of exercising the inherent right of self-defense. This can also ignite boundary conflicts. Although climate change was not foreseen when drafted, the Charter is a living document and provides a constitutional basis for interpreting obligations relevant to this crisis, and exemplifies what Judge DeVischer described as the unforeseen and indeed unforeseeable events that the Charter must address. The Charter was created to save the succeeding generations from the scourge of war. It must now save future generations from the ravages of climate change. Mr. President, climate change is at its core also an existential human rights issue. States have clear obligations to protect and respect these rights, including those impacted by climate change. These obligations are rooted in the foundational principles of the UN Charter and elaborated in the Universal Declaration of Human Rights, a crucial interpretative framework affirming the inherent right to dignity and well-being, all seriously threatened by climate change. The International Covenants on Civil and Political Rights and Economic, Social, and Cultural Rights enshrine these obligations. General Assembly Resolution 7630 recognizes the right to a clean, healthy, and sustainable environment as essential for the enjoyment of all other human rights. The Human Rights Council has also passed several resolutions on human rights and climate change. The Orhenda and future generations' decisions, as well as recent decisions by the European and Inter-American Courts of Human Rights, provide compelling legal arguments that states bear obligations to prevent foreseeable human rights harms caused by climate change. The Office of the United Nations High Commissioner for Human Rights has outlined specific obligations for human rights harms caused by climate change, including accountability and effective remedy. Mr. President, the United Nations Convention on the Law of the Sea is the fundamental legal framework, the constitution for our seas and our oceans. So fundamental and organic that the International Tribunal for the Law of the Sea applied it and extensively discussed UNCLOS obligations in relation to climate change, even though this phenomenon was not contemplated when UNCLOS was negotiated. The tribunal, citing the 2016 South China Sea Arbitration Award, emphasized that UNCLOS obligations extend to both protection from future damage and preservation. Mr. President, states are bound to address the climate crisis within a legal framework that maintains peace and security, respects sovereignty, and upholds human rights. Law is essential to ensure a future where all can live with dignity, security, and resilience in the face of a dramatically changing climate. With the Court's permission, I would now like to turn to Solicitor General Guevara to continue and conclude our oral presentation. Thank you, Mr. President.
I thank His Excellency Carlos Freta. I give the floor back to Mr. Guevara. You have the floor, sir.
Mr. President, in addressing UNGA request, the Philippines submits that any act or omission attributable to a state which results or has resulted in anthropogenic GHG emissions over time, thereby causing climate change, is a breach of a state's obligation under international law. Such act or omission is an internationally wrongful act, which necessarily gives rise to a corresponding legal consequence pursuant to international law. Contrary to the submission of some states and non-state parties, the Philippines respectfully proffers that the obligations in respect of the environment cannot be confined within the strict limits of specific international agreements. The insidious effects of climate change require that the entire plethora of customary international law, general principles of international law, and various conventions and treaties be correlated and applied simultaneously. On customary international law, the Philippines submits that the obligation not to cause transboundary harm, enunciated in the early cases of Trail Smelter and Corfu Channel, reiterated in this court's nuclear weapons advisory opinion, the Iron Rhine arbitration, and the pulp mills case, and included in various multilateral treaties involving the protection of the environment, management of hazardous wastes, and prevention of marine pollution, compels all states to ensure that activities within their territory and control must respect the environment of other states or of areas beyond national jurisdiction. Hand in hand with the obligation not to cause transboundary harm is the state's obligation to exercise due diligence. Attendant to this obligation is the adoption of appropriate measures and the exercise of vigilance in their enforcement, as well as the exercise of administrative control applicable to all public and private entities under its jurisdiction. On the general principles of international environmental law, the Philippines submits that the principles of sustainable development and intergenerational equity are twin principles that are most fundamental when looking into the actions of states and non-state actors as they relate to anthropogenic GHG emissions. While the Philippines concedes that economic development is necessary to further the growth of countries and peoples, it posits that actions relative thereto must operate within a paradigm of non-compromise. We should not compromise the long-term sustainability of resources. We should not compromise the ability of future generations to meet their own needs. On treaties, conventions, and other international agreements, the Philippines respectfully puts forward that the entire gamut of international environmental treaties and documents, as well as that relating to international human rights law, are relevant in the present proceedings. At the core of the actions of states and non-state actors is the most basic of all principles, that the fundamental rights of all races and nationalities, present and future generations alike, must, with no exception, be respected. Mr. President, within the context of customary international law, general principles of international law, and various conventions and treaties, the Philippines maintains that when a state, by itself or through its state actors or other entities whose actions or omissions may be attributable to the state, commits acts or omissions that do not faithfully conform to its international obligations, the same constitutes a breach of a state obligation, and under international law is an internationally wrongful act. The commission of such internationally wrongful act triggers state responsibility with its necessary consequences and carries with it the obligation of the responsible state to cease the wrongful conduct and make full reparation therefor. Accordingly, states affected by internationally wrongful acts of other states in respect of climate change may demand the enforcement of remedial actions, including cessation and/or reparation following the injury caused by such internationally wrongful acts. In the Philippine context, these remedial measures are set out in our Rules of Procedure for Environmental Cases, or RPEC. The rules govern cases involving the enforcement of environmental and other related laws, rules, and regulations, including enforcement of remedies and redress for violation of said environmental laws. The RPEC provides for the remedy of a writ of kalikasan, or writ of nature, a unique and innovative legal remedy espoused by the Philippines and which appears to be the very first of its kind in the entire world. The writ of kalikasan is an extraordinary remedy covering environmental damage of such magnitude that will prejudice the life, health, or property of inhabitants in 2 or more cities or provinces. It is designed for a narrow but special purpose: to accord stronger protection for environmental rights, aiming, among others, to provide a speedy and effective resolution of a case involving the violation of one's constitutional right to a healthful and balanced ecology that transcends political and territorial boundaries, and to address the potentially exponential nature of large-scale ecological threats. Upon the grant of the writ of kalikasan, the reliefs of permanent cessation and desistance, rehabilitation or restoration, strict compliance, periodic reports, and such other reliefs which relate to the right of the people to a balanced and healthful ecology may be granted. Indeed, while the sui generis remedy of our writ of kalikasan is consideredly still of municipal application, such remedial innovation is of value in the present discourse, where climate change is of such magnitude that it imperils present and future generations. Thus, the Philippines respectfully submits the proposition that a similar remedial measure be considered and adopted in the international setting to afford seriously affected states and their peoples with immediate recourse and relief from environmental damage arising from breaches of state obligations under international law. To conclude, Mr. President, Your Honors, the Philippines has no inch of doubt that the entire gamut of international law informs the obligation of states for their anthropogenic GHG emissions in a manner that is far more encompassing than what has already been achieved by the international community under the climate change regime. Now, more than ever, the authoritative guidance of this court is being sought to express in no uncertain terms that the contributory conduct of states in relation to climate change is bound by established conventions, customary law, and general principles. We hope and trust that the court will do so. On behalf of the Republic of the Philippines, we thank the Honorable Court for your time and consideration.